car crash cases, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you. Your tough legal questions answered by our experts. The attorneys with Josh Wright from the law firm of Hollis Wright and host David Lamb.
Welcome into the attorneys. We sure do appreciate you joining us on this Sunday evening. For the next half hour, we have a panel of experts assembled, ready to answer your questions. The way that you get those questions to us is the numbers that you see and the information at the bottom of your screen. So you can call, you can text, you can email. We really try to make it convenient, but love to have you be a part of the conversation on the attorneys tonight. Also a reminder, there are attorneys standing by to take your call, so go ahead, take advantage of that opportunity. Leading our conversation tonight, as he does oftentimes, Josh Wright from the firm of Hollis Wright. Good to see you, sir.
Great to see you too. Hope you had a great week.
I did.
We should probably start the show different because I say that every time.
But I always do have a great week.
Well, life is great. I guess it's good, right?
It's all the good legal advice I get here. I put it right to work.
That's right. So, you know, we're going to be talking about a show. We have done this show in the past. It's been a long time, but we're going to do a show on the Federal Employers Liability Act, or what's called FELA in the industry. Some interesting statistics there. Basically, this statute, federal statute, protects certain rail workers who are injured on the job. And there are some 7,000 to 10,000 railroad workers that are injured in a traditional, year with about 250,000 miles of rail out there. And so it may not apply to each and every person watching the show, but there are a lot of people out there in the Birmingham area that this applies to. Yeah. And when we talk about FELA stuff and we talk about bringing experts on, Tucker Burge, who's been on the show with us before, is someone we go to. So first of all, thank you for being on the show. And their firm, Burge, this is kind of what they do. This is one of the significant things they do in their practice, and they do a great job doing it. So when we have these cases come in, we send them to guys like this to be able to handle these cases. So again, thank you for being on.
Thank you for having me.
We really appreciate it. Talk to us a little bit, how did you get in this niche kind of area of the law? I know you do some other things too, but this is kind of one of your primary focuses. How did you get into this?
I was born into it. Okay. My father represented railroad workers from the time that he started practicing. After he got out of the Marine Corps, he came to Birmingham and started working for a lawyer named Al Reeves. And Mr. Reeves had started because his father worked for the railroad and was a union representative. And so that's how I got involved in it, and there are others in the Birmingham community that got into it really the same way, by working for one of these individuals.
It is a small group, isn't it?
It is a pretty small group.
And it's kind of a specialty area. We'll talk a little bit about this. There are some similarities to workers' comp. Some similarities, not significant similarities, but some similarities between workers' comp and the FELA statute, are there not?
Well, they both apply to employees who are hurt at work, but there are more differences than there are really similarities. The FELA requires that the railroad employee prove some fault, some element of fault on the railroad, either proving that they weren't provided with a safe workplace or that the railroad violated some sort of safety statute. Once they have done that and they've met their burden, they're entitled to compensation at a level that the jury decides. And so there is no code that you go to like the Alabama Workman's Comp. If you're hurt at work in the line and scope of your employment, you recover, but not much. You get a certain number of weeks at an average weekly wage that's calculated in the code.
Let's talk. We'll get back to kind of some of the damages and the success rate in these FELA cases. Let's get back to kind of the statute itself. What's kind of the foundation for the statute in the first place? Why is the statute kind of relevant? Is it just to protect all rail workers, or just some rail workers? How does that work?
Well, historically it started because the life expectancy of railroad workers, or the work life expectancy, was so short that it was just a national tragedy. And Teddy Roosevelt said something had to be done. The statute got passed in 1905, declared unconstitutional, and passed in relatively its present form in 1907. It's been around since then, and it is just to protect railroad workers. It's since been codified that it protects people who work on the navigable waters in the terms of the Jones Act. So it's protecting these people whose work affects interstate commerce.
Something that's just intriguing to me, would it surprise folks how dependent we still are on railways in terms of transporting goods and how used they are? Because I would think things have changed quite a bit since your father's time and whenever he got into this versus yours. But I've seen some numbers recently. We are still quite dependent on railways in the nation, aren't we?
Oh, very much so. And you see the railroads here in the East Coast, the largest is CSX Transportation, Inc., the next largest is Norfolk Southern. They not only have large rail networks, but you see the piggyback cars, the ones that are carrying the containers. They also have big container operations in Jacksonville and other major ports.
Right. Who does the FELA, who does it apply to? Does it apply to, for example, railways that just operate in the state of Alabama, or does it have to be interstate? How does that work?
It has to, it applies to common carriers who affect interstate commerce. Okay. The only railroads in the state that it doesn't apply to would be plant railroads, that is, railroads like Fairfield Southern that just operate inside the U.S. Steel plant over here. It doesn't apply to them because they're not common carriers. You and I couldn't hire them to go carry some goods for us. And it does not apply to the Alabama State Docks Railroad any longer because the decision has come down that they're protected by sovereign immunity.
What happens if an employee at those two facilities you just mentioned gets injured? What do they do?
If you're at the Fairfield Southern Railroad, you would be looking to workers' comp for that compensation. And again, if you're injured at work, you should be looking for a third party. There may be some other way to find someone that you may be entitled to compensation from. If you're hurt on the Alabama State Docks, you would go through the system where you file with the Board of Adjustment in Montgomery.
Gotcha. All right, so the Federal Employers Liability Act, does it apply to all railroad workers? I mean, I know we've talked about it's got to involve interstate commerce, but let's assume that takes place. So the employer is relevant and they're subject to the statute. Does it apply to each and every employee? It
does. It applies to, it applies to the transportation people. The people are taking the trains and stuff, but it also applies to office workers. It applies to the people who maintain the equipment, who maintain the tracks. It applies to supervisors. It applies to the workers when they are being transported in a taxi cab to their hotel to stay overnight before the next day's trip. It really covers everybody, everywhere.
When we come back, because I know we're getting ready to go to break, I want to talk a little bit about the process of initiating these claims, why it's important to have counsel like Mr. Burge involved. I think that will be helpful to the rail workers out there.
Okay, all right. We're our first break of the evening right here. We'll step aside just for a couple of minutes, but when we come back, continue to take your questions for our panel of experts tonight. Call, text, email, join the conversation. Also, an attorney is standing by right now, so a unique opportunity you get every Sunday evening here on The Attorneys. Stay tuned. Our second segment of The Attorneys coming right up.
I'm Carter Clay with the law firm of Hollis Wright. Thanks for watching The Attorneys on WVTM 13. Now we hope you, a friend, or a loved one never need legal counsel for a case. But if you do, the goal of this show is simple: to provide answers and legal counsel when you need it the most. Your call to the show is free, so if you have questions specific to this show or related to other specific legal matters, call, email, or text us to talk with one of our lawyers. You can also follow us on Facebook or Twitter to learn about important legal news that could affect you or your family member. Or simply contact us by going to WVTM13.com and click on the Attorneys link. Now we know your time is valuable, so thank you for spending it with us and for watching The Attorneys right here on WVTM 13.
Welcome back into the attorneys. An impressive change there brought on by legislation talking about the railroad industry, and protecting those workers. Would love to have you join the conversation. You could call, text, email. That information displayed at the bottom of the screen all throughout the program tonight.
Let's talk just for a second. When we went to break, said I want to talk about kind of initiating the claim and the importance of lawyers in those claims. Tucker, explain that. How does somebody, if somebody comes to you and says, you know, I'm a rail worker, I know you need to evaluate whether or not they fit into this statute or not, but how do you initiate a claim once you determine somebody does fall into it?
Well, the way that you start an FELA claim is you file a lawsuit in court. You can file it either in federal court or in state court. There's concurrent jurisdiction. From there it proceeds just like an ordinary civil lawsuit will proceed. The time period in which to file the lawsuit is 3 years. If it's a traumatic injury or a sudden injury, it's 3 years from the day whenever it happened. If it's an occupational claim or one due to repeated traumas over time, it would be 3 years from the time when the employee knew or should have known that they had a work-related condition. And so that's the 3-year period. There are other employee rights, anti-retaliation rights and so forth that have a much, much shorter time. That's why it's important that the employee get in touch with a lawyer quickly. And that doesn't apply just to railroad workers. There are 22 anti-retaliation or whistleblower federal statutes out there that OSHA has to be the first step. And you only have, in this case, for a railroad worker, 180 days in which to file. Some are even shorter than that. So it's important to get a
quick time frame.
It really is.
Can somebody go file one of these cases? Well, maybe I should ask it this way. Should somebody go file one of these cases on their own, or do they need counsel to get involved?
Well, they should not really go and try to do it on their own. Historically, people who have gone up against the railroad themselves have not fared well. The claims department, the people who try to handle it themselves, not file a claim in court per se, but go to the claim agent and try to do things. They're dealing with professionals. The claim agents are very experienced, very sophisticated. They know where the traps are and stuff, and employees who try to handle it themselves historically don't do as well. I've heard one time that the employees who used attorneys got 75 to 80% of the compensation that was paid, and that really only 25% were using attorneys at one point. So
impressive. Question we have here: what types of injuries are covered by FELA?
Any kind of on-duty injury, any kind of physical injury, whether it's sudden, whether it's a repetitive stress type claim like carpal tunnel or degenerative spine conditions due to whole body vibration, occupational diseases, asbestos-related diseases, hearing loss, and even emotional injuries without trauma under the very limited circumstance. If the employee is within the zone of danger and reasonably perceives that his life is on the line, then like in a crossing case where it turned out the tanker truck was empty, but they believed that it wasn't. In those circumstances, the employee can recover for emotional harm only.
Let's talk for a second about how a lawyer who is retained in these cases is compensated. Are these cases, is it governed by a statute, what type of fees you can apply for? Is it based on a contingency? How does that process work?
It is. It's a contingency based fee, just like any other personal injury claim.
We talk a lot about contingency fees on the show. The general theory being that lawyers are willing to take the risk and believe in the client's case, and they will pursue a claim where the client doesn't ever have to come out of pocket for anything. If there's success in the case, an amount can be recovered by the attorney and expenses can be recovered, but only if there's success in the case. And that way the client is protected to not have to come out of pocket to hire and retain a lawyer in these cases, like we talk with some of the other contingency cases.
And I bet that could get really expensive if you're going up against a huge railroad company.
You're never going to outspend them.
Yeah.
They're going to come in, and these cases are defended vigorously. They're going to come through with their experts and so forth, and they really do fight these cases hard, and that's all the more reason to go ahead and
Right.
to get with a lawyer early so that they can marshal the facts. You don't want to give the railroad a head start.
Yeah.
You know, we talked earlier a little bit about some of the similarities and dissimilarities between the workers' comp statute and this statute and this area of the law. And in workers' comp, it's a no-fault system, and people have trouble wrapping their arms around that to say, how can you compensate somebody without having to prove fault? That's a whole other show we could do in
really
workers'
is.
comp. But in this circumstance, proving and establishing fault and responsibility is required, that somebody contributed or somehow caused the injury to an individual. I mean, I would imagine that's not always easy to prove, and it's another reason why you'd want to have a lawyer involved.
Oh, absolutely. You know, in the law, when we speak in terms of duties, they have a duty to exercise reasonable care. Courts have interpreted that to mean that they have to be proactive. A railroad has to be proactive and go out and identify unsafe conditions and eliminate them in order to protect employees from being hurt. And so there is some sort of analysis that goes on. There are experts out there in safety and ergonomics and mechanical engineering and accident reconstruction that are available to attorneys that are used routinely that an individual wouldn't know about.
When we come back, I want to talk about employment contracts and trying to contract around these laws and these responsibilities, because I think it's important for people to understand what an employer can and cannot do.
Good place to pick up. We'll pick up right there when we come back for our final segment of the attorneys. It's still time for you to get in touch with us and join the conversation. Call, text, email. Also a reminder, you can find the firm of Hollis Wright on Facebook if you'll just search that term, Hollis Wright, and also on Twitter, it's Hollis_Wright. Stay tuned, the final segment of the attorneys coming right up.
I'm Josh Firth with the law firm of Hollis Wright. When it comes to a lawsuit against medical professionals, it may seem like the law favors the medical community over the injured patient, and in many ways it does. While not every bad medical outcome is malpractice, it's important to know what obstacles you may face if you're injured as a result of poor medical care. So in tonight's Legal 411, we're answering the question, does medical malpractice really exist? The answer is yes. But if something is ruled malpractice, Alabama law limits the amount of information that can be presented to a jury about a doctor. Medical malpractice is defined as a doctor's failure to use the degree of care and skill that a physician or surgeon in the same specialty would use under similar circumstances. For example, a surgeon can only be judged by the standards for a surgeon, a dermatologist by the standards for a dermatologist. These standards and the evidence that goes to a jury are controlled by Alabama statute, which is called the Medical Liability Act. This act prevents juries from hearing about a doctor's past mistakes or malpractice issues, limits the scope of information available to the injured party, and prevents any mention of liability insurance, which would pay a judgment, the very point of malpractice insurance in the first place. However, even with these restrictions, malpractice cases can still be won. The law does protect both parties and provides access to the jury system for people who have been injured after poor medical treatment. That's why it's so important to get legal help quickly if you face this situation. Please remember, your call, email, or text to the attorneys is always free. All of us at Hollis Wright want to help answer the questions you face on real issues every day. And remember, a competent lawyer will respond to every question you send in. That's our pledge and promise to you. Thanks for watching The Attorneys.
Yeah, you do see trains with some heavy load. Welcome back in, talking about the railways and protecting those workers in that industry. An interesting conversation tonight. Time enough for you to join us, though. This is our final segment. A few minutes remaining. Join the conversation. When we went to break, you were talking about the contracts and the agreements, and we have a question here from an actual railroad worker. Says, I'm a railroad worker who has been injured. When I started my job, my employer had me sign an agreement limiting my right to sue for damages for on-the-job injuries. Can I still bring a claim under FELA, and will my employer potentially punish me for doing so?
Well, number one, there can be no contract or device whatsoever to limit liability. That's part of the statute.
Okay.
It says that if they were to present that, the court would declare it void, and the railroad's lawyers are sophisticated enough that they're not even going to present that. As far as being disciplined, however, up until 2007, before some employee protections were passed under the Federal Rail Safety Act, an employee could be terminated, and his only rights would be able to appeal that termination through his union. Mm-hmm. Now the federal government has stepped in and given some employee protections to promote safety, so that you cannot retaliate against an employee if it plays, or for reporting an injury, if that retaliation plays any part in the report.
If they know that it's void and is not good in court, are those contracts, those agreements still being signed today?
Well, apparently from the caller that they're still doing it, and maybe it's just probably with some of the short line railroads, you know, the employee may not call up, may not see the show, and may just think that they don't have any rights.
Hopefully they're watching.
Yeah.
Let's talk about, for a minute, statements. I know a lot of times after events like workers' comp, for on-the-job injuries, there'll be a first report and potentially a statement that's provided by an employee. In this context, with this type of law, in this area of the law, do employees have to provide a statement at the time of their injury, or should they contact a lawyer first to do so?
Well, they can contact a lawyer or their union representative first, but they do need to fill out the injury report when it's presented to them by the railroad. Generally, before they leave the property that day, they have to fill out the report. The employee should contact somebody, because some of these forms are loaded. There's one that has a question that was there any defective equipment involved? Were you provided with a reasonably safe place to work? Right. Things that the jury would ultimately be asked. They're asking the injured person to you know, give a check mark in this field before we even take you to the doctor. Wow. So
if you get to trial, you think you can keep some of that stuff out?
Well,
because it kind of goes to the ultimate issue. Really.
It's usually Exhibit A for somebody. Okay. In the case, I had a case a month ago out of state where the employee had kept a copy of his report, and the copy that the railroad presented had some of these fields checked, and the copy that he kept did not. It's probably important that if you are going to fill out a handwritten statement of any kind, if you're an employee, not just at a railroad, but anywhere, that you keep a copy.
Another question we have here, I want to see my own doctor for my injury, but my employer is telling me that I must go to a doctor of their choice. Do I have a right to see my own doctor, or do I have to go to the carrier suggested doctor?
Well, this is another way that it's a little bit different than state workman's comp, is that the employee governs his own medical care. The railroad employee gets to pick the doctor that he wants to go see, not the one that the employer picks. This is not a situation, if you want to see another doctor, that you have to get a panel of 3 and you pick one and get the employer to approve it. You have good medical insurance, you can go, and generally the claims department will pay for any medical care that you go to any provider that you choose.
You know, under Alabama law, and I have this conversation with clients a lot, to the extent that somebody contributes to their own injury, they may be barred from recovering under the law, and that's a complicated concept to explain to people. They just don't understand it, and I understand why. Does that apply in this context? Is contributory negligence or contribution towards the injury relevant in an FELA case?
Well, if you are at fault and you are the employee, your recovery is diminished by the percentage of your fault as determined by the jury. Unfortunately, for people who are in Alabama who are hurt and their fault contributes even in the slightest, under a state law claim they wouldn't recover. We are one of 4 states that still have that really harsh rule.
You know, that's interesting because comparative negligence has not been brought in the general context of liability in Alabama, but yet it is in this statute and it's applicable.
For over 100 years, it's been recognized as the fairest way to resolve controversies, and it's embedded into the FELA.
It sounds to me like you're doing a lot of your practice outside of the state of Alabama in other areas.
Quite a bit, and in fact, the people who do this work, we typically end up trying cases in a number of different places. This year I've tried a case in Louisiana and one in Ohio, so it will move around as the year goes on.
Well, and that's kind of consistent with the practice in general, because a lot of my cases, you know, in a different context are out of state too, and it's unique because the law that applies to what Tucker's talking about is going to be unified in all those states because it's a federal law, whereas the law that I may be working on in Texas in a personal injury case is totally different than the law in Alabama. So it's kind of a unique concept that makes it easier to try cases out of state.
Much. You're working from the same jury charges.
Yeah, almost out of time, but just time enough for both of you. Just a final thought from you, and we'll go with you first, just for our viewers, something you want to leave them with tonight.
Well, thank you for having me. I appreciate this opportunity to talk to workers out there, and not just railroad workers. Railroad workers need to get in touch with counsel to find out what their rights, but any worker who's hurt needs to get in touch with somebody and find out what their rights are on the front end. Right. And if they don't do it quickly, some rights, like anti-retaliation rights, may be forever lost.
Well, and I would leave with the same concept, and that is that you know, you want to have counsel involved, and Mr. Burge is somebody that's accomplished and has done this his entire practice and knows what he's doing. This is not the type of case when you come to our firm that we're going to handle on our own. It's going to go to somebody like Tucker and his group to be able to litigate these cases. It's just an area of the law that's so unique that if you're not with the right group that know what they're doing, you can run into some significant problems, and that's why we go to guys like this. So thank you for being on the show. Really do appreciate it.
Thank you for having me.
Appreciate you all being with us. Appreciate you joining us as well. Thanks so much for being with us tonight. Here's how you can continue to get in touch with the firm of Hollis Wright. Thanks again for joining us, and we'll see you next week right here on The Attorneys.